Let's record to the cloud and see what happens. Okay, so I'll press the record button. Good afternoon, good afternoon, good afternoon. Ladies and gentlemen, I'm going to do a little bit of a Jonathan Ross this afternoon because I've got a guest to interview. If you are watching this on the Stanford Gould page, welcome, welcome. If you are watching it on catch up when we've shared it to other groups, you are equally welcome. If you have been asleep for the last 8 months and don't know who I am and have just randomly fallen onto this video, my name's Heather Stanford and I'm from Stanford Gould and I'm the legal fairy godmother to the wedding industry. And today's session is a little Q&A to fit with our theme in the group this week about ADR and mediation. Now, before everyone just dies of boredom and goes, what the hell's that, Heather? We're going to explain. But I thought rather than wibbling with just me on the video, we'd have a guest who actually knows something about this subject more than I do. So I'd like to introduce you to the lovely Chris Adams, a mediator and ADR specialist, who we're going to run through some questions, some Q&A, and sort of answer some of the mysticism, I suppose, the stuff that you have no idea what on earth it is, why it's useful, what it's for, and how it might be relevant to you guys in the current situation. So welcome, Chris.
Thank you very much, and hello everybody. It's a real pleasure to be along. Thank you very much, Heather, and I hope that everybody gets something out of it. So fire away.
Excellent. Okay, so as I said, this is a Q&A really about mediation and ADR. So let's start with a really, really simple basic. What on earth is mediation and what does ADR mean to us as suppliers?
Well, quite simply, ADR stands for Alternative Dispute Resolution. And if you don't go down that route, then the only way of resolving things formally is through court. And some people who are listening might have had experiences in court. And generally, the feeling is one of dissatisfaction by the time you finished in court. It's not a very positive process. And so mediation really offers an alternative, and it can be anything you want it to be. There are structures that are largely adopted by mediation practitioners, and they help to provide a framework for a facilitative discussion to take place. But the idea is for everybody to meet and in very simple and find a solution. But it's important that people are happy with how that takes place. And so it can take any form you like. And that can be telephone now, can be Zoom, can be face-to-face. So it's really what you want it to be.
So it's a pretty flexible solution potentially to people who are stuck in an intracted dispute with someone. Maybe they've had extended email, maybe they've had some nasty phone calls, it's tricky, it's difficult. They haven't managed to reach a solution. There's threat of court. This is potentially a solution they could investigate before that threat gets carried out.
Yeah, very definitely. It can be investigated at the beginning. It can happen at any point in the litigation process. But if you can get to it early, and if you can persuade the other parties that are involved in the dispute to also come along and try and solve it, there's no reason why it can't take place right at the very beginning. And in terms of preserving commercial relationships and in terms of cost and the amount of energy that goes into litigation, if you can sort all of that out right at the very beginning, it's a win-win. It avoids all of the correspondence tennis that lawyers love. And it avoids the formality of court proceedings.
Yeah,
the beauty.
Sorry, I've talked a lot on the group about how important it is to have a dialogue with people in a dispute, and no matter how difficult you might personally find that, no matter how much you want to avoid a confrontation, it is important to have a dialogue and to try to reach some sort of deal with people. It's the point at which you get where you can't progress that any further. Is that where mediation really comes into its own?
Yes, I think it is. Usually, I mean, if people can resolve it themselves, great. And if they're talking to each other, great. And if they've got a mature commercial relationship, they can probably do that. But if they have reached that complete impasse, that deadlock, then mediation can help to unlock that. And it works because sometimes face to face, you become very entrenched, and people become emotionally invested in a dispute, and it means that they can't give ground. And the natural human approach to these things is to dig in, and the combination of digging in and an emotional investment means that you just end up in a complete deadlock. And the role of the mediator is to understand what each party's position is in relation to that, and try and unpack that deadlock, the reasons for it, and what people really want. Because truth be told, everybody's sitting in those rooms because they want to be out of it. They want to have an end to this wretched mess that they're in.
God, yeah, absolutely.
But the very fact that they're human beings means that they're not best equipped to actually get themselves out of it.
Yeah, it's a bit too close, isn't it? It's very difficult to be objective in that scenario, and to work through. How successful is it? You've been doing mediation for a good number of years, I know, and you've had experience at all sorts of ends of the spectrum, from very, very expensive commercial disputes to individuals involved in perhaps smaller value but nonetheless extremely entrenched disputes, and all points in between. What's the sort of success rate for this sort of alternative way of trying to resolve a dispute?
Well, it depends how you actually measure success. But I mean, if you want statistics, then I think the general feeling is that about 80% of cases will settle either on the day or shortly after, as a consequence of the process having been undergone. And so it is very effective, and it is effective in lots of different ways. So, for example, one case that I did that got very, very bitter, and I got drafted in quite late in the day, and it was quite a long and hard-fought mediation. At the end of it, I asked the lawyers, because parties were represented in that one, to come into a side room and put some flesh on the bones of this deal that we'd done. And we walked out, and the parties appeared to have gone. They were not around. And then we found them in another room, having solved this particular dispute, talking about the possibility of having another contract of the same sort. And they were all best friends around the table. And that had obviously helped to sort of unblock the communication, unblock the relationship, and actually allowed them all to move on very positively. And that's probably the warmest feeling I've had at the end of a mediation, because absolutely everybody was delighted with the outcome.
And that doesn't happen much in litigation, does it? My experience of litigation is not much happiness and joy. It is very much a painful and often not necessarily embraced compromise, because a judge is imposing on you. You're not deciding it. You don't have any control over it. A judge decides based on what you present and the evidence that's there, and therefore it's not your decision.
Yeah, that is exactly right. I mean, you lose control of your own case once it gets into the hands of lawyers and barristers and judges. Then you can sit at the back of the courtroom going, hang on a minute, excuse me, this is my case. You're all talking up there, and I don't really understand, and I feel completely removed from it, and it's costing me a fortune, and I'm really not very happy, and I'm also terribly nervous. And all of those things mean that the whole process, I think anyway, in my experience in litigation, I think the whole experience is pretty unattractive. Absolutely. And the beauty of mediation is you have control over it. And the other big benefit of mediation is that it can deliver outcomes that a court can't. So a court can only give you an outcome that's based on the law and what the law allows you to do. Whereas mediation, you go anywhere you like. With your thinking, with your deal, with however you want to structure it. It's one of those things that has maximum flexibility. And while I wouldn't like to give the impression that every single successful mediation ends up with parties embracing themselves at the end, it is effective. And yes, it's hard work. I mean, it sounds very touchy-feely, but it's actually hard work. And people that have undergone a mediation will feel as though they've been through the ringer. And very often everybody goes away slightly disappointed. And if they all go away slightly disappointed, that is the very best outcome for a mediator.
I'm laughing, Chris, because I've used that line because I've known Chris professionally for a number of years. I'm laughing because I've also used that line in my group quite a lot. If everyone comes away from a compromise a little bit pissed off, then it's probably the right compromise. And I've said this endlessly, so I'm really glad that you are now saying that. I promise you, members of the group, that was not planned.
Yes,
we're all coming off.
Yeah, it wasn't a line I've been fed.
So you described a mediation could be like a Zoom call where people dip in and out of mute or video. It could be on the phone, which is very often how small claims mediation happens. And for the majority of people in this group, if they've had any experience of court and mediation before, it would have been in a small claims context where someone from the court rings you, has a chat with you about your case, then they ring the other side, has a chat with them about the case, see if there's any ground that can be given, and see if any deal can be done. So it's something along those lines that we're really talking about, I think, for this group, because the vast majority of the people who are watching this, if they've got a dispute currently, it will be all around the joy that is what deposit has been paid, what money's been paid, and what's been demanded by refund, and what they can keep and what they can't keep. And very specifically within a wedding supplying context and venues and so on. So envisaging a sort of a mediation that might be either on a phone or on Zoom, can you give me some idea of the cost to people and how is the cost covered of this process, and does that require an agreement on its own before you get anywhere near the actual substantive mediation itself?
Well, yes, I mean, it's actually very straightforward. If you've got two parties involved in a mediation and wanting a mediation, they negotiate a fee with a mediator and they split it usually 50-50. So that part of it is very simple. And usually as well, parties will be asked to enter into a mediation agreement. Now that's important for a number of reasons, but particularly to take account of the fact that everything that happens in a mediation is confidential and it cannot be referred to outside that mediation unless you reach a settlement, in which case you sign it all up and it becomes a contract and an enforceable contract. But in order to protect the confidentiality, then you need everybody to enter into effectively a confidentiality agreement. And that is included in the mediation agreement. So in there, you'll see paragraphs about fee, where it's going to take place, the obvious stuff, the housekeeping stuff, but also it will have this confidentiality clause. And that's stressed by all mediators. And confidentiality allows you to speak freely and openly with each party, so that at any one time, a mediator will be carrying three pieces of information. He'll be carrying the information that one party has given to him, and he'll be carrying the information that the other party has given to him. And in the middle, he'll have some of that information that each party allows him or her to disclose to the other. So the mediator has those three pieces of information, and it's the bit in the middle where the parties allow him to exchange that information with their opponent that gives you the space in which to actually find the deal, if you possibly can. So other than that little bit in the middle, everything else is confidential and it goes nowhere else. And that, coming back to the question, is why you have a mediation agreement. But it's not complicated, it's not difficult, it's very simple and very easy to understand.
So do you need a lawyer to represent you in this? Because I know earlier you mentioned mediation where there were lawyers, and I know that those things those sorts of mediations do exist. But what we're really talking about in terms of the people who are likely to be watching this video, is it something you need to get all tooled up with a lawyer, and the expense of that, and you know, in addition to the expense of mediation, is that necessary? And
No.
if it's not, what sort of costs are we talking about ballpark for this type of process?
Well, I mean, first of all, you don't need a lawyer. I've done mediations where there have been no lawyers. I've done mediations where one party comes tooled up with a lawyer and the other one doesn't, and it really doesn't make any great difference, because in reality this is your moment. It isn't the lawyer's moment. The lawyer can have their moment in court if they really must, but this is your moment. It's about what you want to do with the issue that you find yourself in, and provided you can communicate that effectively, you don't need to have a lawyer unless there are really complicated issues in terms of law or any other aspect of what's going on behind the scenes. But generally, and I'd have thought within this group and with many other people who find themselves in dispute, there's no need to have a lawyer. If the parties decide on a mediator, then it's a question of negotiating their fee. Most claims that are for relatively modest sums of money in litigation terms, and I stress that in litigation terms because they're large chunks of money by anybody's standards, but if you're talking about probably a claim of £10,000 or £20,000, something in that area, then you should be able to negotiate a fee with a mediator, probably 500-600 quid for 2 or 3 hours worth of mediation. If it's more complicated, then maybe you'll need a full day, and in that case, you know, it will be a similar amount times 2.
Yeah, I mean, for most of the people who are watching this, and for most of the claims that our group discusses and talks about, they are in small claims territory. You know, they're under 5,000, or they're between 5,000 and 10,000. You know, that's very typical of the sort of money that's on the table in dispute. And I've said before in my group, you know, that there are some very complex legal questions around frustration of contracts and the quantum of damage and stuff. But I absolutely guarantee anybody watching this, there is not going to be anything in a dispute around the refund of a deposit that is so complex it needs a lawyer to be involved in a mediation. In my view, that's my view. You could easily undertake mediation with your customer, and only between you incur the mediator's fee in terms of additional cost, which will probably not be that far off what it's going to cost you to issue a small claims court
absolutely
application, is it?
Yeah, absolutely. And I think you've picked up on a good point there in terms of evidence and those sort of more legalistic issues, because in fact a lot of people think a mediator sits sort of like a judge, listening to evidence and making a determination. Nothing could be further from the truth. Mediators don't want to hear about law if they can possibly avoid it. They're not interested in evidence as such, and they certainly never issue a judgment or a determination. This is all about what individual parties want in terms of getting out of the problem that they're in. And the only 2 questions that a mediator ever has to address with the parties is, what will it take to settle this, and am I prepared to agree it? Those are the two principles that a mediator goes in to try and sort out. And sometimes what you will have is a gap, and then you need to work on that gap so that you can narrow the area of dispute and hopefully get a deal. But those are the 2 issues really, and keep off, as far as you can, keep off the law. Keep off the law.
I know, I say this all the time. God, don't ask me what the law says. This is about a practical compromise, and and mediation is, in my view, one of the quickest and simplest and most effective ways of ending up at a practical compromise that everyone can walk away from and live with. Because again, as I've said in the group many times, a dispute situation is all about retrospectively looking back at what you did, why did you do it, how did you do it, what's the evidence that you did. As businesses and as individuals, none of us want to spend too much time navel gazing at 2020 because
no.
it's been an absolute shitstorm, excuse my expression,
Yeah.
and nobody wants to dwell there about why they did stuff, what retrospectively has happened, which has cast that in a different light. You know, how this thing has unfolded and how we all try to do the right thing at the right time, as far as we could. Those are the sorts of issues that I think mediation would really, really help people to explore, to understand why suppliers are coming from a particular position. I've had no bloody work for 9 months and I basically have no income. And why they're coming, you know, from couples are coming from it. Well, I've just promised to spend 40 grand on the dream day of my life and it's been shattered and I am absolutely on the floor. And both of those positions are entirely justifiable. They have nothing to do with law. And those are not things that a judge will look at. They are things, but they are things that a mediator can explore with parties. And that, I think, is what makes this such a potentially attractive alternative to people in this group, as a way of resolving these impasses that they've reached.
Well, I think you're right. And looking at those examples that you've just given, very often that's what appears on the surface. You've got your 40 grand and you've got your supplier, but very often there are all sorts of stories underneath the surface, which have resulted in those people getting to that position. And part of the joy of mediation is actually getting to what is driving the problem. And if you can get to what's driving the problem, then you are more than likely going to be able to find constructive and acceptable solutions. And sometimes as well, coming back to the human condition, you know, if people have a major problem going on below the surface and they share it with the opponent, then actually that can cause the opponent to shift their position markedly. They just didn't understand that. They didn't know that. And when it's presented to them, they go, you know what, you know, that's a pretty awful position to be in, or whatever it might be. And yes, we're going to adjust our position. So again, the skill of the mediator is to get underneath the surface. I mean, none of that will apply in a court. Absolutely none of it.
No. Yeah. Well, you and I both know that, don't we, from our previous lives?
It does not happen. Yeah.
They're not interested, and that is not the purpose of a court process at all. Whereas it can be part of the purpose and process of a mediation. So there are going to be people watching this video who are thinking, well, that sounds quite intriguing. I'm quite interested to know a bit more about that and whether that could work for me in this particular dispute. What's the process here? Do they have to approach you and say, please, can we engage you? Do they have to talk to their opponent, the person that they're in dispute with first, and say, look, I've got this idea for a possible resolution. What do you think? What do they do first? In what order? And where can they find more information about the steps that could lead them to your door, or indeed any other mediator's door? Because, you know, as they say on the advert, Mr. Adams is not the only option for this service, but he's the one we're talking to this afternoon. So tell us about what they do from here if they think that sounds interesting.
Well, crucially, in order to arrange a mediation, you obviously need everybody to agree, because everybody has to be there. So a logical place to start is actually suggesting to your opponent that mediation should be something to embrace. And I think that is the logical place to be. And after that, it's a question of saying who you want to mediate. And you can say, yeah, I want this person, that person, the other person. And you can go to a number of places to get lists of potential mediators. There are mediation groups all over the internet. Alternatively, if you know a mediator, pick up the phone. I mean, people just phone me or drop me an email saying, would you be interested in this? Can you do it? Are you available? What's it going to cost? All those sort of things. And once they've got all of that information, Then they can go to the other side and say, this is the person, this is what it's going to cost, this is how we're going to do it. And so the thing comes together in either of those two ways. If people are unsure how it works, then yeah, pick up the phone, have a chat first about that, and then go and have a word with your opponent. I think to some extent it depends how good your relationship is with your opponent, whether you're communicating at all, or whether it really is very difficult. And it'll be for each party to judge how best to actually handle that. But if it's very difficult, I would recommend getting all of your information up front, and then putting it in front of your opponent, saying, we need to try this. More importantly, the court will try this. We're happy, ready, willing and able to do it. We found this person who is available. What do you say? Here's the number, here's the email, get in touch with them, you have a chat as well, and if everybody's happy, let's get a mediation arranged as soon as we can.
Great, because there is an obligation, and again I've referred to this in other lives before, where and if anyone's seen the blog that we posted back in the summer about pre-action protocol, and everyone going, what the flip is a pre-action protocol? So it's the process, it's the documented process that the courts say anybody must go through. They must jump through these hoops before they get anywhere near issuing claims. And back in the summer we were saying there were a lot of people who were jumping the gun a bit before issuing claims and had not investigated the alternative options. So if you've got someone, someone who you're in dispute with who is just going, I'm just going to issue my claim, I'm just going to go on Money Online and do it. This is very much an obligation of all parties who want a dispute to be resolved by a judge. The obligation is you must look at some alternatives before you step foot over that metaphorical threshold. And it doesn't mean that everybody has got to do a mediation. What it means is that everybody has got to look at other ways of resolving the dispute without needing A, to start a claim, or B, ultimately having started a claim to get in front of a judge at a final hearing. So as Chris said, mediation is one of those aspects, but it is an obligation of everybody to look at alternative ways of trying to reach an agreement without ultimately standing in front of a judge. And the other thing that I'd just re-emphasize to the group, and I've said this to quite a number of customers in the last 2 weeks, a judge is not going to have a flipping clue how the wedding industry works. They're not going to have a clue. They might not. I mean, they may have got married. They may have paid for a wedding, and maybe they've had some personal experience, but they are not going to understand the wedding industry in the way that you think maybe I do as a lawyer. And if you've had experience with other lawyers, good, bad, or indifferent, you may have reached a stage where you thought, I'm not sure how much you really understand about my industry. And we have this conversation in the group quite a lot. How much do you understand about the industry? Well, quite honestly, if you're in front of a judge in the county court, small claims, he's not going to know much about he or she is not going to know much about your industry either. So the nuances that you might want to raise as part of your argument are going to be lost. Whereas in mediation, there's a real chance that you, A, can set them out, B, you can explain them and see why they're important, and D, they can often reflect on an answer. So I'd really genuinely, for people in this industry, who are currently grappling with that whole, how do I just deal with this and move on because it's wearing me down, it's costing me time, effort, it might not be costing you money directly because you haven't got a lawyer dealing with it, but it's costing you time, it's costing your business time. Mediation is really a way of trying to move on to that solution and then on to other things, much nicer things, hopefully more positive things for 2021. And our challenge, this month is very much about challenge 2021. What have businesses got to do now to get themselves up and running and going again come 2021, be that February, if that's the date when we move on, or whether that's later, who knows? I don't have the crystal ball, as I've said before. But getting this stuff resolved now, this side of Christmas, there's a real window of opportunity, in my view. There always is, to try and use the new year, that line that's coming up in the sand, to try and get some of this stuff put to bed, moved on, sorted. And one of the options that you might want to think about is mediation. Now, if you are watching this thinking, this sounds like something I really would like to investigate further, Chris has got a Facebook page, and we're going to put some links below this feed about how you can get in touch with him by email or via the Facebook DM. Although I might have to run him through a short lesson on how to pick up the DM, because this is not his forte. Bless you, won't mind me saying that. But so we'll give you the links if you want to pick up the phone and have a chat with Chris about whether or not he, as a mediator, can help you resolve the dispute that you're in, then please do. If you can't contact him via that, you can always contact me and I will put you in touch directly. But what I think the main message is, there are people about in this group and in this industry who, in my view, badly need the options of mediation. They do not necessarily have to use Chris, but here's someone on my recommendation who absolutely knows what he's doing, who absolutely can deliver that job to you, and who absolutely can help you to explore whether this is the right option for you. And I would recommend having a look at that option and seeing if that's better than wondering how you're going to file a defence. And have you set out on your list of documents all the emails that you've exchanged with your opponent, and can you be bothered to trek all the way to, I don't know, Dorking County Court for 2 hours of a small claim hearing next March? Or between now and then, is there something you can do proactively to make that pain go away? Because this is a solution. It is not a painless solution. It is not an easy solution necessarily, but it is a solution which is not ending up in front of a judge having no idea where you're going to end up at. So thank you for joining us for the session. Thank you, Chris, for being available to come and chat nonsense with me for 20 minutes. We may well do a little preview for the group too, and this will be going live on Thursday, and then we'll be sharing it to some groups, particularly amongst venue customers, because I think there's a real need there, I think, for some resolutions to some what might be slightly larger amounts of money, but no less complex or difficult questions for them to resolve. So we're going to share the post liberally. If anybody needs more information, you can contact Chris through the links that will be on the bottom of this feed, or you can contact us through Stanford Gould and we'll point you in the right direction. And hopefully that gives you some food for thought about alternative ways of progressing with this stuff to a place where you can park it and move on, because that's the most important stuff. So thanks, Chris. Really appreciate your time this afternoon.
Well, thank you. Yes, it's a difficult time for everybody at the moment, and if it's possible to, as you say, package some of this up and get rid of it and move on more positively into 2021, so much the better. But yeah, thanks for giving me the opportunity to talk to all of your links, and hopefully we'll be able to resolve a lot of their issues.
Let's hope so. Let's hope so. So thanks for listening, guys. If you've got any questions, obviously put them in the feed. I'll be keeping an eye on the feed during the course of the next few hours. So if there are questions I can answer quickly, I will do. If usually you ask me really difficult questions and it's not stuff that I can answer in the feed, but I'll do what I can. And if we can't, we'll point you hopefully to some resource that can. Have a look through what the other posts on the page this week. We're talking about ADR, mediation, pre-action protocols, all stuff court related and dispute related. So there's plenty of resource there in the group and on the Stanford Gould online page. So please do go and have a look and check us out. Thanks again for watching, and we'll be back next week with another helpful, useful guest to talk about some of the challenges for 2021. Stick with us. Bye. Right, I have stopped recording.